Did you know that in today's society, it has become increasingly easy to falsely accuse an innocent person of sexual assault crimes? And that even if you are 100% innocent, California law currently makes it very, very tough to defend yourself against these false accusations.
To discuss the changes in our modern society and important legal developments that affect innocent people, we're going to bring you this informative video, which will focus on 5 common scenarios where innocent people can find themselves falsely accused of sexual crimes. And we're going to discuss some of the common myths and misconceptions that people have when they're facing this legal situation.
Please stay tuned to the very end of this video, because Roland and I are going to bring you a list of 10 important things that any person, but especially an innocent person, facing unfair, disgusting, false sexual assault allegations can do in order to protect themselves, in order to improve their legal situation, and to stay out of trouble. My name is William Pernik. I'm a criminal defense attorney and a founder of the Pernik Law Firm. Here with me is my law partner, Roland Soltes, and my long-term friend. Now together, Roland and I have handled literally thousands of criminal cases. But it seems like in the most recent years, we're handling more and more accusations of sexual crimes than ever before. Now, Roland, I don't know if you share the same observation as me, but I feel that in the last 6 to 8 years in particular, we have seen a significant rise in the number of clients accused of sexual assault, probably more than in all of my years of practice combined. Do you feel the same way?
Yes, I absolutely feel the same way. The number of sex cases has never been higher, especially since the COVID lockdown and also the George Floyd incident. It seems like there has been a deliberate focus by law enforcement on these cases, and the numbers have just exploded.
You know, it's really interesting, Roland, that you brought up the George Floyd scenario. I know you and I share some philosophical differences on this here, but I've always associated the rise in a filing of these sexual assault cases with the birth and development and evolution of the Me Too movement, which I felt made it a lot easier to accuse a person of sexual assault. And since the overall numbers of sexual assault allegations are higher, I always felt that it's much easier to hide false accusations among the true ones. Tell me what your different perspective is on this.
Well, I agree with what you're saying, because the Me Too movement definitely made it easier for people to make these accusations, whether true or false, because clearly some of them are true. But I also feel the George Floyd situation changed the way law enforcement operates.
Interesting. When you say that it changed the way it operates, what do you mean by that?
Well, with law enforcement, it used to be they go out, they pull people out of cars, they bust down doors, they do drug searches, and all that they did was bring grief to the police officers. But when you're dealing with the population of sex offenders as a whole, not a single police officer has ever got any grief for prosecuting a sex crime. Whether the accusations are true or not, all they get is an attaboy.
Interesting. So, Roland, your theory is that independent of the rise in cases due to the birth and development and sort of evolution of the Me Too movement, we're also seeing an increased number of sexual assault investigations and filings because our police officers prefer to focus on investigating sex crimes as opposed to sort of more traditional encounters that cause them nothing but trouble.
Absolutely.
So in today's video, we'd like to talk to you about the 5 most common areas that we come across on a daily basis that breed false accusations of sex crimes. The first area where we see a lot of innocent people get falsely accused is the area of internet dating, which brings with it unique issues related to age and consent. The second area where we see a lot of false accusations is in the area involving intoxication. In this scenario, when people have sexual relations and also consume alcohol or drugs, oftentimes questions arise as to whether or not the sexual activity was in fact consensual and whether the people who were engaging in this activity had the legal capacity to consent.
The third area where we see a lot of false accusations pop up is in the aftermath of relationships. A lot of times people break up. They have kids together, There's all kinds of accusations that are flowing back and forth for a variety of reasons.
But in particular, I would say, Roland, when child custody issues arise and people are fighting over who gets to spend the most time with their child or children and who gets to pay for it. And also, let's be frank about it, because California law creates presumption in favor of custody being awarded to a parent who was a victim of domestic violence or sexual assault. All of that sometimes can create a very good reason for somebody to falsely accuse their former partner of sexual assault or domestic violence.
The fourth area where we see a lot of false accusations is where adults interact with children on a regular or professional basis. These are typically cases involving school teachers, athletic coaches, preschools or daycare operations, or even somebody that's put in a position of trust involving a friend's child or children or extended family members, friends with kids and family members. But it's the adult interaction with children that we just see an extreme amount of cases on.
And within that area, one of the topics we're going to cover specifically is the area of adults who interact professionally with children in a home daycare or preschool setting, because that is an area where a lot of times it's very easy to accuse a person of false sexual misconduct. And you've had these exact scenarios, Roland.
Yes, absolutely. The fifth area where we see the most false accusations on a daily basis has to do with step-parents. This area in particular is just a breeding ground for false accusations.
The role of a step-parent is admittedly a very difficult one, but unfortunately, it often brings with it issues of divided loyalties, biological parents being involved, child custody situations, and especially scenarios where the step-parent is forced to become the disciplinarian, and how that oftentimes results, unfortunately, in false reporting of sexual misconduct, especially when it's reported to people who are mandated to forward the report and act on it, such as social workers or teachers or other types of professionals.
In the remainder of this video, we're going to take each one of these 5 sections and we're going to talk about them in depth. We're going to give you the most common situations that happen during those scenarios and how to deal with them. But in order to help you understand the 5 areas of false accusations, we wanted to briefly cover some of the common myths and misconceptions that occur on a daily basis that people have about sex accusations. 5 myths and misconceptions that people have about sexual assault cases.
Roland, the first thing that comes to mind when you talk about this is this notion that people have that you actually need to have a lot of evidence in order to accuse and, more importantly, to convict a person of a sexual assault crime. And that's just simply not true under California law.
No, that's certainly not true. Under California law, there's a jury instruction, Cal Crim 1190. And what 1190 says is that specifically in sexual assault cases, testimony of the complaining witness by itself is sufficient to support a conviction. No corroboration is required to convict a person. As long as you believe the victim or alleged victim beyond a reasonable doubt, and a lot of people really don't understand that and how deadly that can be in this type of case.
So that means that if the little kid just gets up there on the stand and says, "Hey, he touched me," and the jury believes it, you go to prison. And if a pretty young woman gets up on the stand and says, "Hey, he raped me," and the jury believes her, you go to prison. Even if this allegation happened 5 years ago, 10 years ago, 20 years ago, no one else has seen the behavior, there is no forensic evidence supporting this allegation, and there is no confession. No corroboration is required. And because of that, this can be really devastating to a person who is accused of a crime.
The second thing that comes to mind that we hear from clients when they come in our office all the time is, "Hey, can I just take a lie detector test? That'll clear me. I'm sure I'll pass it."
It's very interesting that you bring up the lie detector test, because I think that the general public is under the impression that somehow there is this magical tool that an innocent person can get plugged into and it will produce clear and definitive results of a person's innocence. And while this tool does exist, because after all, lie detector tests are available and we've used them in the past, the reality is that the law in California today actually makes the results of a lie detector test legally inadmissible in a jury trial. So even though there are some legal circumstances where these tests can be used, for example, they can certainly be used for plea negotiations, for informal discussions with the district attorney. They can be court-ordered, which I find personally to be somewhat disingenuous, but they can also be court-ordered for purposes of sex offender counseling or treatment once a person has been convicted of a crime and placed on probation or parole, for example. And even though a court can fine a person, for example, in violation of probation or parole for failure to comply with a lie detector test or lying on that test, these tests are just not considered sufficiently reliable, Roland, in order to help an innocent person clear their name when they're facing false accusations of sexual assault. And I'm worried that the general public doesn't always know that.
And the third misconception that we hear all the time is we have parents or brothers or even our clients come in. They say, well, the other person is very sexually active. They're with 12 different people. Doesn't that count for something?
That's very, very true. Oftentimes we're dealing with cases where our clients will report or our investigation will reveal that a complaining witness is sexually promiscuous, that a complaining witness perhaps has a lengthy history of promiscuous sexual behavior. And to our clients, to their parents, to their family members, and quite likely to future jury, this all appears to be very strong, very powerful evidence that this person should not be believed, especially on the issue of consent. But unfortunately, in California, and specifically under Evidence Code Section 1103, for example, evidence of victims' past sexual behavior with others in particular is legally not admissible to prove certain issues, such as consent. These are rape shield laws in California, and they were enacted in order to protect victims or alleged victims of sexual assault. But unfortunately, this is the downside to them, and it could really hurt an innocent person. Now, there are some exceptions to this rule, for example, and some of these exceptions may allow creative lawyers to admit some of this evidence in a person's trial if, for instance, it goes to issues of someone's credibility under Evidence Code Section 780 or 782. But generally speaking, California rape shield laws prevent evidence and prohibit evidence of victims' past sexual behavior from being introduced in a criminal jury trial. And that's true even when this is something that there is a lot of evidence of and where it may frankly be quite probative on some of the legal issues. You have to file a special motion. You're going to have to withstand very critical scrutiny by a judge who is likely going to favor a victim in a sexual assault case for a variety of reasons, including some political ones. And it is exceptionally difficult to get that evidence admitted. But most of the people in the general public absolutely are not aware of that.
The fourth area in misconception that we deal with that we wanted to cover is taking the stand. A lot of people believe that ultimately, when that person comes and takes the stand, they're going to tell the truth. In practice, we haven't found that to be the case, have we?
I agree with you. Sadly, we discovered that by the time a criminal case actually goes to trial, which could be in 3 months, in 6 months, 9 months, maybe a year later, the person who has made the allegations of sexual misconduct, sometimes an adult, often a child, has been so far removed from the alleged offender, they have been so brainwashed, so trained, and so indoctrinated that by the time they come to court to testify against you, you will not recognize the person you once raised, you once lived with, you once loved, the person you interacted with. So it's always a shocking and surprising experience for our clients, but unfortunately, it happens all the time. And similarly, when our clients take the stand, they seem to think that as long as I get up on the stand and I testify a certain way about what happened, I'm going to be believed. But that also is not always true. Sometimes jurors don't believe people even when they tell the truth.
When you're dealing with children, they have practice court. They take the kids in the courtroom, they practice asking and answering questions with them. They go over an interview that they did 2, 3, 4 months, maybe years ahead of trial, and they make sure that they're exactly on script, that everything they said before is the same. They have a support dog, they have stuffed animals, all these things to make the children feel comfortable and create a positive reinforcement for them. And the problem with that is that by the time these children actually take the stand, it's going to create an impression of a confident child who vividly remembers what has happened to them as opposed to a well-practiced one.
And I think a lot of people don't realize that witnesses before trial are usually prepared. And that's true for both sides. But in particular, when you're dealing with someone who has made allegations in the past, who has perhaps been interviewed 3, 4, or 5 multiple times, they may have given statements to several police officers. They may have given statements to a lead detective. They likely have been interviewed by a forensic social worker. And now they're being trained on how to answer these questions properly. Perhaps not directly, but indirectly. So all of that results in a witness coming to court and, Roland testifying with confidence about things that happened, when in fact maybe these things didn't happen at all, or did not happen quite in a way that they're describing.
The fifth area we'd like to talk about today is the area of pseudoscience, a highly misleading type of expert testimony that has been developed and is very widely used in order to help prosecutors obtain convictions in sexual assault cases, particularly involving children. This is something called CSAAS, Child Sexual Assault Accommodation Syndrome. This is a theory allegedly admitted to disabuse the jury of misconceptions it may have about how children behave and report when something happens to them, and is especially misleading because basically anything a child says, these doctors will testify that it's consistent with child abuse.
Yes, and to go into it a little bit more, usually what we see in a case involving, for example, a child who may be falsely reporting that abuse happened when it didn't, is something like this. Sometimes a child waits to report for a very long time. So naturally that raises a question. Well, hey, if all of this horrific abuse allegedly happened to you, why wouldn't you have mentioned it to your grandma? Why wouldn't you have mentioned it to your mom? Why wouldn't you have mentioned it to your auntie who was picking you up and driving you safely one-on-one to school for the last 6, 7, 8 years? Why did you wait until you were 17 years old and got in trouble in school to report this incident? And so that's obviously a problem area for the prosecution. And in the past, Roland, when you and I were just starting out in our careers, 15, 20 years ago, jurors would nod their heads and say, yeah, that's a big problem. Why would you wait for so long? Are you telling us the truth? But see, now they will call this fake expert who will charge the county exorbitant fees, often in the thousands of dollars, and they will come to court and say, well, based on my experience working with children who have been victims of sexual assault, children may not report that something happened to them for a very long time, so even if the child waits for a ridiculously long time, it's entirely consistent with being abused. Or you could have, for example, a child making different statements about what happened, being totally inconsistent with what they reported from one person to another. And so obviously, again, if you're a defense attorney, you're going to ask some very probing questions like, hey, when you first spoke with your grandma, you said that nothing happened. When you spoke with your aunt after that, you didn't report anything. But then you get in trouble with your teacher, and suddenly you're saying completely different. And then you were interviewed by 3 police officers and a social worker. And each time your story had a little bit of a discrepancy here. So obviously, once again, clearly a problem area for the government when the witness is all over the place. But in these types of cases, they will call their trusted fake expert, pay them thousands of dollars, and this academic type will once again take the stand and testify that in his or her training and experience, this behavior also is consistent with abuse. So this is just a really bad science, Roland, because no matter what the evidence is in the case, these paid fake experts are going to come and tell the jury, hey, don't worry, you can still convict. This could totally be true regardless of any doubts you may have or frankly should have. And since the child is cute, confident, has now practiced telling their story multiple times, there is this nice professor with a bow tie telling you that these problems don't matter and the child may well have been abused. Regardless of these inconsistencies, this creates a very high risk of false conviction, even if the person is completely innocent. Topic 1. Internet crimes.
The age of the internet has brought with it unique challenges and problems that our clients face on a daily basis. Some of the biggest problems areas that we see that are in dispute on a daily basis are cases involving issues of either age or consent.
I agree with that, Roland. I think primarily when we're discussing legal issues related to the age of the person that one of our clients is interacting with online, I think it goes without saying that people need to use extreme caution when they're interacting with people online who they do not know and who represent to them that they're adults, but may very well turn out to be children who are being deceitful and lie about it.
Yeah. I mean, a great example was when several clients I've represented were on a website called seekingarrangements.com. Everybody has to be 18 that's on there. However, when somebody's placing an ad, they can self-certify that they're 18. So you really don't know who you're dealing with. I had one client that was conversing with a girl online. She turned out to be 13. However, she was sending pictures, messages, nude photos to scores of men. Every one of those men who were receiving those images were committing a crime, unbeknownst to them. Now, our client actually wound up meeting with this person in person, thought she was 18, found out after the fact that she was under 18. But that poses an especially big problem for our clients.
In particular, when dealing with persons under the age of 14, California imposes something known as strict liability, which means that even if you were misled, even if you genuinely believed that the person was older, if you have sexual relations with a person who is under the age of 14, you are held strictly liable for the crime, regardless of your individual knowledge or your criminal intent. And so for that reason, Roland, I agree. I don't think people can trust when websites certify someone's age. I think people need to go a step further. I think people need to pay very careful attention to representations that are made to them, and they can't just hear what they want to hear and then do what they want to do. I think it really places the burden on the adult who is interacting with a person representing themselves as an adult who perhaps is a little bit more useful. So that if you are a 47-year-old man and you think you're interacting with an 18-year-old or 19-year-old woman, you need to go the extra step. And you need to truly make sure to check the ID. Be polite about it. Be a gentleman about it. You don't have to be a jerk. But you need to protect yourself and make sure that you don't end up in a situation where you heard what you wanted to hear, did what you set out to do, and now you're facing some very serious legal accusations for having inadvertently committed a crime involving a minor, a sexual crime.
That's correct. Checking the age, making sure of the age of the person. You just don't know who's behind the screen. There's somebody out there. They could be a variety of people you need to check. Another area where we had problems with age that we've come across is people that are conversing over the internet in fantasy situations.
Oh, I agree. In fact, Roland, this was, and I'm glad you brought this up because, and maybe this betrays our old age a little bit, but we actually had a case involving somebody who was participating in fantasy discussions on the forum involving DDLG. Now, you and I had no idea before we got this case what it meant until a young former legal assistant in our office clued us in, and it turned out that DDLG stands for Daddy Dom Little Girl, and it turned out to be an explanation and a potential defense for the client. But what we learned is that there are actually adults out there, for example, who fantasize in a sexual way about being daddy's little girl or mommy's little boy. And quite often it goes to extremes and discussions about sexual activities that happen when people are very young. And so if you're an adult having conversations that revolve around fantasies involving younger people or pretending to be younger people, you have to be very, very clear in establishing boundaries between where fantasy ends and reality begins. So you don't end up in a situation where you're thinking you're sending text messages or sending sexual messages or sending nude photographs to a person who's role-playing being 16 years old or 15 years old and turns out, in fact, to be 15 or 16 years old, sending you back naked photographs of themselves that have just gotten you convicted of possessing or distributing child pornography or sending obscene or lewd matter to a minor, because those are serious accusations in California. They could send you to jail or prison and require sexual offender registration for a very long time, sometimes even for life.
And even in these fantasy situations where somebody's an adult, but they're pretending to be a kid, but the police think that you thought they were a kid, you could be prosecuted in that case as well.
Moreover, Roland, you could have a police officer pretending to be a kid. In fact, that's a standard practice. You could have a police officer engaging in a large sex offender sting operation, and we had one here in Monterey County, where an officer goes online, posts an ad pretending to be a 15-year-old girl, and in one case in particular, we had an officer pretending to be a Hispanic girl, which brings into it all kinds of other ethical and legal issues. But that cop went online, stole a photograph of a young girl from her Facebook account, built an entire false identity around it, placed an ad online in the casual encounter sections of Craigslist, and used it as bait for sex offenders. And so it created a situation where he pretended to be a kid, luring people into an adults-only section of the website, but then dropping hints in the middle of this erotic fiction that he may be 14 or 15, that he can't drive, that he needs mom to check his homework, that he needs somebody to come pick him up. And so all of these people think they're interacting with an adult at first, then they get some messages in the middle that one thinks would raise a suspicion that they're dealing with a kid, but they're not sure. And then when they showed up to meet with the person they were interacting with, they end up meeting a police officer and they get arrested. And even in the situation where you have zero intent to meet up, but you are acting like you want to meet up, and you're talking to this juvenile who's really an adult, but the officers think you're talking to a juvenile, you can be convicted of an attempt to lure a kid, where you might think it's a fantasy. You might think you're online playing out these fantasies, and there's hundreds of them that people engage in, and lots of these fantasies can get you in trouble. So the goal here is to keep you out of trouble. And to do that, you got to make sure that you know you're talking to an adult. Anytime there is a fantasy involving juveniles or a discussion involving juveniles. And related to that, we also had a number of clients, because you and I have an interesting practice, my friend, but we also had a number of clients whose fantasies are of the kink variety, or rape fantasies, or rough sex fantasies. And it certainly is not unlawful for consenting adults to share certain interests that may lie outside of the mainstream. That's totally legal. But you do have to be very clear in your communications and in your conduct after you've had these communications, so that both sides are on the same page as to where reality begins and ends and where fantasy lies. Otherwise, you're potentially exposing yourself to criminal liability. You could be accused of making certain threats, when in fact you're just role-playing. And if you meet somebody after these steamy chat conversations, thinking that they want to engage with you in the same way as they have been describing it online, you may be mistaken. And you may now be looking at sexual assault allegations.
Yeah, it's okay to have a fantasy, but when you have those fantasies, you need to include a disclaimer. I know this is only fantasy. Even if it's one sentence that you write or tell the people, make sure it's recorded. Make sure it's documented. So that way, you stay out of trouble.
And another issue that often arises in situations involving internet dating is the issue of consent. Someone could meet a stranger online, discussions take place, people likely exchange some sexually promiscuous messages, maybe they exchange some photographs, they might discuss some activity they want to engage in, or share some fantasies. Then they meet in person, relations take place, and later a person is accused of sexual assault. How do you protect yourself from something like that?
Well, once again, you have to be clear in your communication, because when you're meeting somebody for the first time on the internet, whether it's for sex or any other person, you've never talked to this person before. You don't know what their background is. You don't know what their motivation is. So in order to protect yourself, you have to have clear communication. You have to document it. Even if it's a tape recording of yourself and the partner, and you take your phone out and you record, my name is Joe Smith, and I'm here with Jane Doe, and both of us consent to sex with each other, or something like that. But there needs to be something that you put out there so you protect yourself, because not everybody's fantasy is reality.
Yeah, preserving evidence is really something that comes to mind when you talk about these recordings. I think a lot of people are engaging in online dating or internet dating, and they might, while they're enjoying the activity in the process, they might nonetheless feel embarrassed about it because of societal stigma, or maybe because of issues related to fidelity or infidelity. But what we oftentimes see is that people will have an act with the person they met online, and then they go back to their regular life and they quickly delete any and all evidence of this illicit affair or any and all evidence of this meet or date. And sometimes in our line of work, that can be really dangerous because some of these sites you're on may not preserve your private communications. And if you've had these discussions about sexual fantasies, about kink fantasies, about rough sex fetishes, or any other things that you want to do to one another, and suddenly you delete them after you've acted on them, and then you're accused of sexual assault, well, you may have just lost evidence that this was a planned consensual activity between two consenting adults, as opposed to you meeting somebody for a different reason and then forcing yourself on them. And I think that's quite dangerous for an individual.
That's right. You should always maintain records of your communications of consent. It's very important in order to you to have a happy and healthy relationship with these people. I mean, you really need to keep track of things.
I also think that when we talk to people online, Roland, we have to remember that we're interacting with human beings. And human beings have emotions, human beings have feelings, human beings have needs. And we're talking about personal or emotional needs, not just sexual needs. And so what I think oftentimes happens is that the internet dating cheapens the interpersonal relationships between folks, and it results in people acting crudely. Perhaps people acting in a way they would not have acted with a person if they had known them, or maybe if this was a person introduced to them by common friends or family members. And so I think when sex becomes a commodity, when interactions are reduced to a transactional level, you expose yourself to additional dangers that perhaps if that's what you plan to do, which you shouldn't, but if you plan to do it in that way, if you engage in a transaction, you need to have a clear understanding of what transaction is about and how this transaction is going to proceed. And what happens, as you've always taught me, what happens if there is a breakdown in the middle of this transaction?
Just like a businessman does a contract. This is a transactional nature, and you should have a contract too.
I mean, if that's what a person decides to do, I know that in our colleges, it's an interesting thing that you brought up a contract. I personally think it's absolutely ridiculous as far as our society is concerned, that we're teaching kids in colleges to sign off on sex contracts or consensual contracts, where folks are now discussing in writing, these are the things that I permit you to do to me if we have relations, and these are the things that I don't permit you to do.
So, I know how you feel, but the freshman orientation for my daughter, when she went to college at UC Santa Barbara, we're there as parents, and one of the things during freshman orientation, they were handing out consent forms. If you're going to have sex, and of course, me and her mother looked at each other and said, what is this? But at the same time, when you start thinking about, it's easy to make these accusations. If both people just sign a quick piece of paper ahead of time, then there's no misconception.
I mean, as a lawyer, I tend to agree with you. But as a person, as an adult, as somebody who believes that we shouldn't reduce human interactions to transactions, I also feel quite uncomfortable with the idea of having to sign a piece of paper where we can say, okay, I can kiss you on the left shoulder, but not on the right. It just seems ridiculous to me.
Yeah, well, I don't think we need to go into these details. But if two consenting adults just sign a form, I consent to have sex with you. You consent to have sex with me, and all that entails, it pretty much protects you.
I think that would be an extreme form of protection, but I understand your point. The other way to address it is the rule that I think we would like most people to live by, which is, how about you just be a decent person? Be a gentleman. When you're interacting with a lady, you had sex, you got what you have come for, you wanted to have sex with this person you met online, great. But, be also sensitive to their means as a human being afterwards. Don't just disengage completely like it meant absolutely nothing. Don't cheapen it. Don't reduce it to just a sexual transaction. I think if folks just take the higher road and act a little differently, that could probably cut down on some really hurt feelings and perhaps reduce the number of false allegations out there.
Yeah, I tend to agree with that statement, that it's always better to be a decent person and a decent human being, but the internet has reduced this to a transaction. And when you're entering a transactional business, it doesn't really cheapen it because you're already in a transaction. You need to protect yourself.
The last thing I want to say on the subject is that I don't know if you remember this or not, but we had a client a while ago who was in the Kink community. And he wanted to protect himself against potentially false allegations of certain acts during these sessions he was having with multiple partners. So we actually had an associate of ours draft a contract for him, which I think was an interesting assignment for our employee, to say the least. Topical area number 2, intoxication. A very important area we want to talk to you about, which is fraught with significant legal problems for people, is the area of intoxication. We all know that people have been consuming alcohol and sometimes drugs and engaging in sexual behaviors probably since the dawn of time. And yes, it is completely socially acceptable and legal to invite a person out for a drink, perhaps meet them at the bar to have a couple of drinks, and later, when you're feeling nice, relaxed, and comfortable, to engage in a mutually consented act. The problem, however, lies with situations where people consume so much alcohol that they either no longer consent to sexual activity or are no longer capable of forming consent.
Yes, William, that's correct. Under California law, there's a point where you're so intoxicated that you cannot consent to a sexual act. And so as a person, you have to be cognizant of who you're with and their condition. If you think somebody is so intoxicated they can't realistically consent, then you do not have consent and you should not go forward. It goes back to the same thing that we've been talking about on other videos. Be a human being. Understand where somebody's coming from. We had a case where I talked to somebody just recently where he met a woman in a bar and they both were extremely intoxicated. And they went to the bathroom and had sex in the bathroom at the bar. Afterwards, the woman came out and she was so drunk, all of her friends said, "Well, what were you in there? Why were you there so long? What were you doing?" And she basically admitted to her friends that she was having sex. Well, all of her friends were just shocked. And they said, "Well, you're so drunk, you can't consent to that." They called the police. And this guy wound up being arrested for rape, for an act that happened in a bar, as unseemly as that might seem. But you can't consent. You can't go to that 9th degree. You have to understand limits. Nowadays, it's so easy for people to make accusations. They have misinterpretations. Men, women, everybody's more empowered today. They understand the ramifications of that. People are not silent. They've been trained to speak up, so you have to act accordingly.
I think that's true, Roland. And I think that it's very important in today's society to understand that alcohol is no longer a simple defense. That you can't just say, "Oh, I was so drunk, therefore there is no criminal liability for me." I think that today, in 21st century, in modern times, that claim is going to be seriously scrutinized. And only cases where you truly were so incapacitated, so intoxicated, that you could not form requisite criminal intent would be the ones where the defense would work. And then even not in most of them. It would really depend on the circumstances.
Yes. And it's not just alcohol. It's marijuana. It's drugs of any kind. You have to be cognizant if you're using any kind of substance that alters your personality or state of mind or alters the other person's. The danger is even greater on drugs because people don't understand the potency and how it acts on people. Some people could take 3 puffs of marijuana and they're going to be as high as a kite. And they don't have the capacity to consent. And they might do things they wouldn't normally do. So you have to be cognizant of everything that you do that involves substances.
Let me ask you a related question, Roland. And this is kind of an interesting one.
Okay.
What if people decided to get really high and then have sex? Like they discussed it in advance. They said, "You know what? Me and you are going to get blazed. And then once we're so blazed that we feel good and we want to get together, we're going to hook up and have crazy sex. We're just going to go into a hotel room and do it." Do you think there is a legal way by which people can consent before the fact to get really high and have sex and therefore be shielded from criminal liability? That's an interesting question.
So as an example, William, we had a client who had a woman. She liked to get really drunk. And once she would get drunk, and I'm talking about blackout drunk, she liked to get choked. Okay. And in addition to getting choked, she liked to almost get, let's put it, sexually abused. Let's put it that way. And he did this to her. And then The next day she called him back and said, I don't remember consenting and I don't remember doing this. And then all of a sudden, lo and behold, the investigators are at his house and she's reporting him for rape. So the problem is anytime you enter in a contract that is so outside the norm, you have to be really careful. I mean, now, if I'm a jury in a case like this and I hear some evidence during the trial and it's like, well, she signed off, she can smoke as much marijuana, and then they're just going to have sex. Most jurors are going to say, okay, well, they agreed to this. It's consent. But there's got to be a time where people, even when they consent, can withdraw from that consent.
And I think I was just thinking about that. I think the problem with this specific scenario, Roland, is, and I think that's why the legal answer is likely no. The problem is that if you agree to use a lot of drugs or drink a lot of alcohol and then engage in sexual activity while really intoxicated or impaired, you are permanently closing the door on someone's ability to withdraw their consent later. And so I don't think the law permits that. So I think the answer likely would be no, you cannot do that. You cannot agree to that ahead of time. Although obviously it would be ultimately a question for the jury, and the jury can always nullify, which is where the jury decides to do the right thing based on the circumstances, even when it's contrary to the law or what the judge is telling the jury to do. But personally, I wouldn't count on that because it's unlawful and it's illegal, even though some juries do it.
And also, if it's a contract to participate in an illegal activity, which some drugs are, then that contract would just be null right on its face, and it really wouldn't be valid.
Because you can't enter into a contract to participate in illegal activity under the law.
Not at all.
An area that's fraught with false accusations of sexual abuse or sexual misconduct is an area of the aftermath of person's relationships. When a relationship ends, it's a very tense and very messy time for all of the parties. Sometimes there is infidelity for one or both of the partners, and so we have a lot of accusations of misconduct in terms of domestic violence, in terms of sexual misconduct, and oftentimes misconduct towards the children, whether it's child endangerment or child abuse. There's also issues of division of property too, and sometimes there are issues of significant financial interest at stake, so people can lie.
Absolutely. I mean, emotions are really high. I mean, in these types of cases, we see all kinds of accusations flying that come out. And one where we see the greatest amount of accusations, and we'll talk about that first, is child custody. Isn't that where we see the most?
Yeah, I agree with you, Roland. I think that nowadays a well-educated person who has access to the internet can very easily figure out that the nuclear option they have available in terms of winning whatever they want in court, at least for a substantial period of time, is to make an allegation that the other person has done something inappropriate sexually, either to themselves or, more importantly, to the child. There is a very problematic presumption in family law cases in favor of the person who is a victim being awarded child custody. So what that means is that if one spouse alleges that they're a victim at the hands of the other spouse, or their child is a victim at the hands of the other spouse, the spouse that's victimized gets the custody of the children. And that's going to be awarded virtually every time in family court. So this results in protective orders being issued, the other parent being entirely removed from the child's life, and this is going to make it much easier to then manipulate that child, brainwash that child, and influence their potential testimony, not only in family court, but more likely in a criminal case where someone like you and I are going to encounter this.
Yeah, absolutely, that's right. And these accusations, quite often, they ultimately turn out to be false. However, while you're going through it, it's really hurtful to the family, to the kids, to everyone involved. As we talked about previously, any accusation is almost impossible to disprove just by saying, I didn't do it. And most of these accusations, there's no proof other than a statement that this happened. It's devastating to the entire family. But one party gets what they want. They get custody. They get money. They get something out of it. So, William, when people are breaking up, how can somebody protect themselves against these false accusations?
Well, it's very difficult, Roland. And I think rule number one is probably to check your emotions at the door. It's very important, again, to be a decent human being, to put the interest of your family and other people first, and to make sure that you act above and beyond reproach, that you take the higher road wherever possible. I mean, obviously, consult with your family law attorney, protect your legal interests, but you don't have to be a jerk or you don't have to be petty or vindictive while you're doing this. You don't need to be unnecessarily hurtful. Most importantly, you need to be very careful. And what you do to protect yourself the most is to document with specificity, with particularity, any past accusations that were false, any past threats to accuse you falsely. We've had that quite a lot. Any past dishonesty outside of infidelity. Infidelity by itself may not be enough because it's not unlawful anymore to cheat on your spouse. But anything that shows that the other person is a liar, that the other person has motive to lie, that they're hurt, that they're vindictive, and that they're out to get you. And particularly important, if that person has ever threatened to get you in trouble, if you leave them, you got to document that. You got to document that they're capable of doing this to you. You have to preserve it, and you have to share it with your attorneys as early as you can.
So, William, should a person give up custody, potentially, or give up something in the short term for peace to avoid the risk of having a false accusation in a really heated situation?
You know, it's a tough question, Roland. I think that depends on individual situation, and those are decisions that a person would need to make after consulting with their lawyer. I don't know that I would necessarily advise somebody to stop seeing their child. That seems to be extreme. But I certainly think that in a heated situation, perhaps a more conciliatory gesture that has to do with a minor accommodation, maybe something that has to do with finances, something that has to do with property, something that maybe has to do, we see that quite a bit, shared responsibilities around child pickup or child drop-off, things that cost less to give up than not seeing your child. I certainly think that if you can avoid going down this road by giving up something minor in order to gain peace, in order to gain something far greater, I think that should be considered on a personal level and not necessarily solely on a legal basis or a legal level.
Now, William, when people break up, it's not just child custody where we see issues. A lot of times we see, and quite often pops up, is when all of a sudden you have a new girlfriend or a new boyfriend. And then we see accusations start coming out of the woodwork as well. Doesn't it happen a lot? Haven't we seen just like a ton of cases like that?
Yeah, absolutely. I mean, you have a case of potentially some infidelity or bubbling divorce, and then one person has moved on, but the other person has refused to accept it. I mean, human nature is such that it happens all the time. And so the first person starts showing off their new girlfriend online, happy photos of the new couple holding hands, having a grand time, you know, sipping cocktails together. And all of a sudden, your former partner decides, oh, you know what? I'm going to exercise the nuclear option. And now they're saying, well, during our marriage, he would repeatedly get me intoxicated and then proceed to sexually assault me. Or that person might say, you know, during our marriage, he would do all of these other things to me sexually that were never reported, that there is no evidence for whatsoever. Or perhaps there may have been evidence of some consensual acts in the past. Maybe this couple was into some kink experiences together. Maybe they took or recorded videos together or took photos, and maybe that left some marks or bruises. And all of a sudden, this gets manipulated. It gets misused, and it gets misreported inappropriately in order to get the person in trouble. So when relationships come to an end, if you know that something like that exists in your past history with this person, if you know that maybe you had consensual rough sex with your partner some time ago and she sent you a picture of a mark you left on her, maybe you got to be very careful. Maybe you got to use good judgment and sometimes take a higher road. Maybe make some concessions. Be mindful of how your behavior with the new girlfriend or the new boyfriend could affect your family, because you're vulnerable to false accusation of sexual misconduct at this time.
Yeah, and some of the things that I've seen come about in that area is when exes start communicating with each other, it's never a good idea. It never seems to end well, does it, William? It never ends well.
Yeah, I find it really remarkable, Roland, that there are now these internet groups, you know, for women And I suppose for men as well, where they can get information about the person they were in a relationship with. You know, they can exchange hints or tips or talk about things they learned about a person. And so in a post-breakup scenario, that creates a fruitful ground for people to essentially get their stories together, to obtain information that's embarrassing and sometimes could lead to somebody being framed for a crime they didn't commit, you know?
Yeah. And in addition, sometimes when we see these types of communications, it devolves between the exes where we see social media posts and people are threatening each other and a lot of things happen. So to me, the best advice is to stay out of social media. Don't engage. Lay low until the dust settles. The best way to stay out of trouble that way is if somebody wants to start and spread rumors about you, you don't need to engage. Once again, take the high road. Ignore it. Don't have your new girlfriend, your new wife, your new boyfriend respond. That's never a good idea.
Rarely a good idea. I agree with that. And again, you just have to be sensitive to the fact that if you have moved on, but your former partner has not, if you left your family with children and you started a new relationship, maybe it's not the best thing to do to go online and rub your new relationship in everybody's face. Maybe use some discretion. Maybe use some good judgment. I mean, it's not unlawful to do that, but it's bad practice, it's poor tone, and it certainly could result in somebody getting really upset at you and saying things falsely once they think that this relationship is permanently over, that you never quite believed they were capable of saying about you. And unfortunately, we do see that. We see that in our practice.
Yes, we see it all the time. False allegations against adults who work with children. An area that is fraught with false accusations of sexual misconduct or abuse is when adults deal with children on a daily or regular basis. This could be teachers, this could be after-school programs, this could be coaches.
This could actually be daycare workers. I think one of the first things that come to mind, Roland, when you're describing this, is certainly the notion that people can make themselves appear quite suspicious even when they engage in completely innocent behaviors, if they're not mindful of how their acts might come across. And I think the number one rule here that we would want to share with our audience is that if you are a professional, if you are a teacher, if you are a coach, if you are an adult who interacts with children in an academic setting, please be very careful with boundaries that you set so that you're never alone with a child outside of those appropriate boundaries, doing the kind of things that lie outside of what you're supposed to be doing.
Yeah, that's correct. I mean, even if you think it's a normal behavior, the best suggestion I can give you is to try and not be alone with the child. It is almost always best to have somebody with you. Or if you're alone with the child, there's no other children or other adults around, it needs to be in an open area, an area where people can see you, an area where anybody can walk in at any time. It cannot be an enclosed space. Any place where you're open to accusations. You need to be careful with where you're at and your situation and your surroundings at all times. And think of how that might appear to someone else, William.
I agree with that. And I think where a lot of people that you and I represent get in trouble is when out of their, goodness of their heart, they decide, oh, I'm just going to go take this child home after hours because their parents are late picking her up. And then on the way home, you decide to treat them to some Starbucks. So you stop by a coffee shop. And before you know it, you're a 49-year-old man sitting in a car alone with a 15-year-old at night, talking about life, talking about whatever else this child might decide to share with you. She might want to start talking to you about her boyfriends or sex or something that happened. And so with good intentions, you've just put yourself in a vulnerable situation by appearances alone. You've made yourself vulnerable to accusations of something inappropriate taking place.
That's correct. It's not just men. It's women that are also involved. We've had some cases where there have been women who have been accused of sexual misconduct with school-age children that are much younger than them. The important thing is to be aware of your situation. Be aware of your surroundings. And do not have any extended periods of time alone with the child without proper supervision.
Yeah, and related to that, Roland, I think it's also important that you have to make sure that when you are communicating or interacting with a child who's entrusted to your care, your supervision, you're always acting appropriately, and you got to remember who the adult is, and you got to avoid appearance of impropriety at all times. That means it's a bad idea for you to friend somebody else's child on social media.
Yeah, very bad idea.
It's a bad idea for you to be sending private messages to that child on Snapchat
A very bad idea.
on Facebook,
Yeah,
you know?
Very bad idea.
It's a bad idea for you to be sending personal photographs, to be receiving personal photographs from that child, because one of the things is you never know what the child might decide to send back to you. You could find yourself inadvertently in possession of an image that amounts to child pornography. If, for example, you send some borderline risque photograph to a child you're coaching or your student, and then this 15-year-old or 16-year-old or maybe even a 17-year-old student of yours decides to send back a nude photograph because maybe they have a crush on you, and you just try to be nice and you were trying to talk to them on their level, and now you've exposed yourself to a very serious criminal behavior and liability that comes with it.
It's very important to be aware of your surroundings. Be aware of who you're talking to. Be aware of the subject matter. It doesn't matter whether you're a teacher or a coach or whatever interaction you're having with the children. You always need to remember that you are being watched. Now, if you want to communicate with kids, with children, it's okay to have group communications. It's okay to set up a Facebook page, groups for a sports team. But what's important is you do not want to be the one having one-on-one communication with those youths, because that's where we find allegations come up that are false. So to protect yourself, you do everything to a group. You make sure that everything you do is above board.
You also might want to share some of the things you're doing with the child's parent. Remember, they're not your friend. You are their teacher or their coach. The parents are entrusting that child to you. So, for example, you could say, hey, Mom and Dad, I just want you to know that your child sent me a personal message on Facebook. It's totally fine. I think your child is very nice and quite lovely. I really would love to work with him or her. But it's my practice to not accept personal messages. And so I just don't want your child to be upset with me for not doing that. I make it a habit to make sure that nothing I say or do when I interact with children is somehow misconstrued, and that's why I didn't accept the message, but I want you to know that it was sent to me. Or you could make sure that if you were giving somebody's child a ride, because maybe a situation came up when you needed to do that, maybe it's an emergency or something, but you might want to catch the parent up when you decide to embark on this journey. Maybe you text them and you say, hey, your child lost her bus pass and I'm going to give her a ride. Is that okay? Or you text them to say, hey, I'm outside of the house waiting for you guys to come out. It's kind of dark. I don't want her to go in. Something along those lines. But again, the more you blend personal and professional, the higher is the likelihood of you getting in trouble. So generally speaking, it's not a very good idea.
And one last thing that you can do as a teacher, as a coach, there's a variety of internet programs out there for secure communication that you can have if you absolutely must have communication with these kids. Use the appropriate channels. Use secure communications to communicate where everything is recorded. And it's not a bad idea if you make sure that the juvenile's parents are included in this communication.
Right? You certainly don't want to do it on Snapchat where these messages disappear. And then after the fact, if somebody accuses you falsely, people are going to wonder, oh, why is this 53-year-old teaching assistant talking to a 15-year-old girl alone on Snapchat? Because even if you're not doing anything wrong, that creates an appearance of impropriety, even if there is no impropriety in fact. And if you are employed in a home daycare or a preschool setting, you have to be especially careful not to interact with other people's children the same way as you would interact with children in your own family, which is where I think you and I have had at least half a dozen cases of people getting into some serious trouble.
Yes. It's very important in a daycare setting that everything you do is above reproach. It's very important that only the people that are licensed and listed as workers have interaction with the children. We find so often that a well-meaning elderly family member wants to help take care of the kids. However, when they interact with the kids, they might pick up the kids. They might hug them. They might kiss them. And that's where the trouble begins. You just need to separate the professional from the personal. You cannot act that way with other people's children.
That's a really good advice, Roland. That's exactly right. If you're running your home daycare as a business, then approach it like a business. You need to make sure that you interact with children as you would interact with customers, because that's your customer base. Now, obviously, you want to be sweet and appropriate and loving and caring, but you cannot step down to the level of interaction that you would have with your own grandchildren. You can't be giving them rides on your shoulders. You can't be kissing them. You cannot be excessively hugging them, especially if you're an older male. And your behavior could create an appearance of impropriety, even if there is absolutely no impropriety there.
Yeah. Some parents are very hypersensitive to any touching with their kids. If a small child comes home, if they say, let's say the kid's 3 or 4, and they say to their mom, "Mr. Bob kissed me today," with some parents, immediately the alarm bells are going off. They're calling the police, an investigation starts, where this could have been the most innocent thing in the world, where it's just a small peck on the cheek. But before you know it, they interview you, you admit to kissing them, and guess what? The handcuffs go on you and you go to jail. We've had cases with that exact scenario, unfortunately.
You always want to make sure also to maintain appropriate staff-to-child ratio to avoid any situations where you may have to take a child away to a bathroom and end up in a position where you're one-on-one with a child for a prolonged period of time. And you want to certainly avoid creating a perception of something inappropriate happening, which then gets reported by another child to their parent that you were alone with so-and-so for a long time in a bathroom. And then this parent calls another parent, and before you know it, rumors have started. And then you find yourself to be a suspect in a criminal investigation. And I think disproportionately, Roland, I don't know if you agree with me on that, I think it disproportionately affects males.
Well, absolutely, it disproportionately affects male. So it's important that as a male that you're always watching out. But the last 5 years, we've had a significant increase in numbers of females getting charged with this stuff. So it's important that everybody is careful what they're doing.
I agree. And always remember, these problems are easier to avoid than to fix after the fact. So please, be smart, be careful, and above all, be appropriate and be professional. If this is a business, run it like a business.
False allegations against step-parents. An area where we see an awful lot of false allegations is in the step-parent area. It's very important, if you're the step-parent, to be above reproach in everything that you do. Quite often we have kids that might prefer the other parent, the other biological parent. Anything you do that's improper, the kid will report back to that parent. And before you know it, the police are winding up at your doorstep. It's very important that you're not the primary disciplinarian. When you have stepkids, if the other biological parent is actively involved, make sure that the biological parent is the one that's putting out the discipline. Yes, you should have input. You're a couple. You should be talking about things. But make sure the biological parent is the one that's actually implementing this discipline. Or at the very least, do it jointly.
As an aside to this, I know you've been in this personal situation.
Yes.
Is that a rule you followed in your personal life?
100%.
Really?
Yes. Keeps you out of trouble with the kid, the other parent, and more importantly, your spouse.
That might be a good rule too.
That's the best rule. Yes.
Okay. So even if you do find yourself in position where your significant other relies on you to be the male figure, for example, in the relationship, please make sure that everything you do when it comes to discipline comes from the right place in your heart. We always tell clients, for example, never punish when you're angry, right? Never do it out of anger. Do it in order to teach a lesson, but don't do it when you're angry. Use appropriate professional support and be sure to involve other professionals where necessary to address the behavior by your unruly teenager. And, you know, Roland, very often we see allegations of sexual misconduct come from kids who have been indoctrinated in these topics in their school settings. And some of them are quite sophisticated for their age, especially with older teenagers. And so they know that, hey, if I get in trouble, for example, for cutting class, for having drugs on me, for going out with older boys, for sneaking out, for having cell phone when I'm not supposed to have a cell phone, for talking to adults, maybe sexually online, these kids know that all they have to do is make an allegation that their step-parent is somehow touching them inappropriately or abusing them inappropriately. And then what do you know? All of a sudden, all sins are forgiven. Everybody forgets what trouble you're in. And the focus is all on your victimization or alleged victimization and not on that child's transgressions or misbehaviors. So with that in mind, if you're the step parent, please be aware of that. Be very, very careful. And remember, you got to protect yourself at all times. Make sure to delegate, like Roland said, where possible, disciplinary decisions to your spouse or your significant other. And if you're in a school setting or a medical setting or working with social worker, please remember, anything the child reports to a social worker, to a nurse, or to a teacher will be reported to law enforcement, because all of these categories of professionals are mandated reporters under California law. It is illegal for them not to forward a report of abuse, even if they don't believe it. And so as a result, this will be the start of a criminal investigation, whether you like it or not, whether or not the mandated reporter even believes the child. And then once police get involved, this may take on a life of its own and start something you may not be able to stop down the road.
You also must remember that all communications need to be proper with your children, especially any stepchildren. Do not talk sex with your stepkids, not if you're an older male talking to a younger female without her mom. Do not act like you're their best friend. You're still a parent, and you need to act like one.
I agree. It's a good rule to live by.
It's an absolute good rule.
To stay out of trouble.
To stay out of trouble.
Sometimes, even if you are above board in all of your behaviors, you may still find yourself in the middle of a criminal investigation. And so it's very important for you to memorize the following telltale signs of becoming a suspect that Roland and I are going to share with you. Number 1, if for some reason you receive a message, a phone call, or a strange email from a person you once had some kind of relationship with in the past, and that person is accusing you of misconduct, be immediately suspicious that the person has reported you to police and is now trying to drum up some sort of sexual accusation against you.
Yes. Number 2, if the police contact you to talk to you about any kind of allegation, don't talk to the police. They are not your friends. You are a suspect. In fact, you're suspect number 1, and the police officer will be trying to do everything they can to put the handcuffs on you, to get you to incriminate yourself. The best advice in that situation, if the police officers do contact you, is to say, before I talk to you, I really think I need to talk to an attorney, just to make sure. And then contact an attorney. Use a professional. Use their advice.
Rule number 3, never, ever, ever apologize for something you did not do, because legally, your apology may be treated as an adoptive admission. Even if you have done absolutely nothing wrong, and you've been above board and extremely careful with how you interact with others, you could still become a suspect in a pending criminal investigation. So it's extremely important that if you suddenly get that text message, get that phone call, or another form of communication accusing you of something that you know you have not done, you must not apologize for it, and it is critical that you immediately disengage from any further communications with that source, that you immediately have alarm bells go off and you contact an experienced criminal defense attorney.
Absolutely.
Because chances are the person on the other end trying to communicate with you is actually a police officer or a police officer standing next to somebody who just made an allegation against you. And what they're trying to do is incriminate you, trying to get you to admit to something you didn't do, and trying to build a case around you being the suspect.
Once again, even if you're meeting with that person in person, they could have a wire on them. They could be tape recording the conversation. They could be prompted by police officers. Anything that comes out of the blue that's sudden, that you're unaware of, be wary and suspicious about that, because 90% of the time, that somebody on the other end is controlled by a police officer, and you absolutely do not want to speak to the police. That would be a big mistake, wouldn't it, William?
Absolutely. Even if you're fully innocent. And Roland, just listening to you talk about that, my mind is immediately flooded with memories of many, many cases that you and I have had, where it was shocking to me, especially earlier on in my career, the extent to which police officers will go in order to psychologically pressure a suspect to admit or to apologize to something they didn't do. I mean, we had one case in particular, you might recall that a few years ago, where our client was accused by his former stepchild, who contacted him out of the blue, decades after the fact, and started saying things like, I've been talking to a therapist, I'm suicidal, I want to kill myself, I need to get closure for all of the things that you have done to me. And then our client was just feeling really awful, completely lost, afraid to disengage for fear of what that person might do to themselves. And so they made a mistake and they started saying things like, hey, I'm sorry. I'm really sorry about that. And then, of course, later that predictably played out as a form of confession.
Yeah.
And then you had a case a while ago where someone used a different take on this. The police officers got them to talk about hypnosis and how supposedly during their hypnosis session, these memories were somehow revealed, and they showed your client committing these, heinous acts. So the length or depths of creativity to which police officers will go to try and trick someone into admitting something that they may not have done, it's really quite breathtaking, isn't it?
Yes. I mean, it's just amazing what they'll say and what they'll do to get somebody to admit anything. And we do know in California that under law, a complaining witness, if believed, is enough evidence without additional corroboration. But often the district attorneys want more. They want something else. The police officers know this. Jurors want to hear something else. Even though they are allowed to convict on the testimony in sex cases of only one witness, they want something else. The only way they're 99% of the time going to get that is when they get a confession.
All right.
And more often than not, those confessions are in the form of some kind of apology when the person on the other end is lying to you about being suicidal or cries about how hurt they are and how many people hear it. And even if they've not done anything wrong, they feel compelled to say, I'm sorry, to comfort them, which is, of course, what the officers are after. The only proper answer that anybody should ever give is, I don't know what you're talking about, and I suggest you get counseling. There's nothing else to do. And then you hang up or disengage and report this to the best lawyer you can find.
I agree. If a police officer suddenly calls you and invites you for an interview, you may be shocked to hear that somebody wants to talk to you about some sort of sexual misconduct that you weren't involved in. And so it's human nature that you want to find out what it's about. You want to go there and explain yourself. Don't do that. Do not accept a meeting with a police officer. They're not there to figure out what happened. They're not there to help you. There's no way you're going to talk your way out of getting arrested or charged with a crime, even if you have done nothing wrong. The best solution that you have and the best chance of success down the road that you have is to immediately hire the most experienced criminal defense attorney with experience in defending sex cases and decline any opportunity for the police officers to interview you, to trick you, or extract any kind of confession, admission, or an apology, and protect yourself at all times to stay out of trouble.
Yes, that pretty much goes to our general rule about police contact. William, should you ever talk to the police?
Not unless you want to stay out of trouble every single day of the week. 10 important things to remember to protect yourself against false allegations of sexual misconduct. Number 1, if you interact with strangers online prior to engaging in real or simulated sexual activity, be especially vigilant around issues of age and consent.
Yes. Make sure to verify the person you're communicating with is actually an adult and do not trust somebody else, including the website to do that verification for you.
Number 2, if you met that person online and then had sexual relations with them, please make sure to not delete any messages or communications or interactions with them that could later be used by your attorney to show that this was a planned consensual encounter.
Number 3, remember to treat people with decency and be considerate of their feelings and expectations to prevent vindictive, false allegations of misconduct down the road.
Number 4, if you have sexual relations while under the influence of alcohol or drugs, please always make sure that the other person is actively consenting to this encounter and document it whenever possible, before and after the fact.
Number 5, Be mindful that breakups and child custody battles are especially dangerous when it comes to false allegations of sexual misconduct.
Always act above board and avoid appearances of impropriety at all costs. Document with specificity any past threats, dishonesty, or past false allegations that the person may have made against you or even somebody else. And if the person you were with is known to you to have made threats against you or others in the past, and you actually want to avoid being falsely accused of a crime, use good judgment before deciding to either hook up with them or get back into a relationship with them after an argument.
Number 6, if you're an adult working with children, please remember to always maintain proper boundaries at all times. Do not put yourself in situations where you're alone with a child under circumstances that could suggest that you're doing something inappropriate, even when you are not.
Rule number 7. Do not communicate with children outside of normal working hours, and do not give them rides or hang out with them in one-on-one settings. Always use appropriate official channels for communicating with children under your care or supervision. Don't friend them on social media or use Snapchat to interact with them one-on-one. That creates an appearance that you are wanting something else out of your interaction with a child other than being an appropriate professional, and you do not want that.
Yeah, if you blur personal and professional boundaries while working with juveniles, you're asking for major trouble. Just don't do it.
Rule number 8. If you receive a strange phone call or a message suddenly accusing you of something that you know you didn't do, or coming from a person that you have not talked to or interacted with in a very long time, you should be immediately suspicious that someone is trying to frame you or accuse you of a crime, and that the person you might be interacting with on the other end might in fact be an undercover police officer.
Number 9, do not talk to police officers either in person or over the phone, and immediately hire the most qualified criminal defense attorney to help you stay out of trouble. It is better to have the help of a qualified lawyer and not need it than to need it but not use it and find yourself in much deeper in trouble and much greater financial expense down the road.
Rule number 10. Please remember that allegations of sexual assault and sexual misconduct are among the most difficult ones to defend yourself against, even under the best circumstances. And for that reason, if you make mistakes early on in the process, those mistakes could end up costing you your freedom, your family, and your reputation. We hope you enjoyed watching this video. If you have any questions on any of the topics we covered, Roland and I love interacting with our audience online. So please send us a message, click like, subscribe, and stay out of trouble.